Hello and welcome to ProfDale's Property Video number 33. I'm your host, Dale Whitman. In this video, we're going to cover interpreting covenants and terminating covenants, two related subjects. We'll begin with interpreting covenants. One of the problems with covenants is that they often use terms that are used in everyday life, but when we begin to examine them closely, we discover that the meanings of those terms can be quite uncertain. Now, we're going to go through several examples, and I want to warn you that I'm not going to give you any definitive answers. The reason is that the courts don't give definitive answers either. Instead, they look at the facts and circumstances of each case, the context in which the words were used, and sometimes they'll even go back and take testimony from the original developer of a subdivision, for example, or the original drafter of a covenant as to what it might mean. The first question we'll consider is, what do we mean by a house or a home, since those terms are frequently used in drafting covenants. Suppose the covenant says each lot shall be occupied only by a single-family home. Does that include a factory-built house, one that's brought in on a truck and simply assembled? Does it include a mobile home? Often mobile homes are skirted. They may have pitched roofs like the one in the picture, and they may look very much like a conventional stick-built house, but they're really not. What about a recreational vehicle, such as a motorhome, as you see in the lower corner of the slide there? If one is parked more or less permanently on a lot, is that a single-family home? Finally, what about a condominium project? Often condominium projects look very much like apartment buildings, and we would say that those were multifamily and not single-family homes. But in the case of a condominium, each individual unit is owned usually by an individual family. And so one can argue that a condo project is really just a collection of single-family homes. We may have similar questions about the use of the word residence. You might say, well, everybody knows what a residence is. It's a place where people live. But people often use their homes, their residences, for other activities in addition to day-to-day living, and that begins to raise questions for us. Suppose the covenant says lots shall be used for residential purposes only. What about a model home and sales office that's used by the developer during the marketing period of a subdivision? Eventually, that unit will be sold to a family, and they'll move in, and it certainly will be their residence. But during the marketing period, it's really being used for commercial and not residential purposes. Does this mean that the developer is in effect violating his or her own covenants? What about using your home as a daycare for children? Usually the owners of the home will live there, but during the day they'll have a lot of additional children there, something that might trouble the neighbors. So that neighbors may sue and claim that really isn't residential use. Well, the truth is it's partly residential and partly not. Similarly, if you have a home office for a CPA or a lawyer or any other kind of professional, one might say, well, you're living there, so that's residential, but part of the use there is non-residential. It's really commercial or a business activity. So does that violate the residential only purposes covenant? What about using your house for a beauty shop or a barber shop? Much the same kind of problem. What about a timeshare residence? Suppose this is a unit which is split up and sold into 50 different one-week intervals, and each interval is owned by a different person or family. They may come and live there during that week. Does that mean that it is a residential use, or is it really more like a hotel with transient rather than long-term residence use? What about using your house as a bed and breakfast? Usually the owners live there, but they also have lots of guests coming in and out, often on a daily or every 2 or 3 day basis. Is that a residential use? An Airbnb presents much the same problem. The difference is that with an Airbnb, usually the owners aren't present, but people are coming in and out using the unit, much like a hotel. Does residential imply long-term living there, or is a short-term B&B use going to be acceptable? A further question is, what do we mean by a family? Suppose the covenant provides that lots shall only be used for single-family residences. Does a family include as many as 3 or 4 generations of relatives living in the same house? What about a family with foster children who aren't legally related to the parents? Suppose we have a group home. There are many different kinds of group homes, some of them more acceptable to the neighbors perhaps than others. A group home for convicts who've recently been released from prison, sometimes called a halfway house, is one example. Another is a group home for mentally handicapped adults. Another is a group home for physically handicapped adults. Finally, we might have a group home for pregnant teenagers. All of these, in some ways, resemble a family, but are they literally a family? Well, of course not. They're not legally related to each other, and yet many times the courts have held that they are similar enough that they ought to be accepted as a family for purposes of the covenants. We might also think about which ones of these the Fair Housing Act would apply to, since if the Fair Housing Act prohibits discrimination, it'll be illegal and not permitted. The convicts, probably not, but the Fair Housing Act does apply to handicapped persons, persons with disabilities, whether medical, mental, physical. So probably the last 3 group homes would be covered by the Fair Housing Act, and a covenant that screened them out would violate the act and be illegal. Now, you might have seen housing that's designed for older people, usually retirees, and commonly the sign will say it's a 55-plus community, and you might have wondered how to square that with the Federal Fair Housing Act. The Fair Housing Act prohibits familial status discrimination, and familial status, you may recall, is defined as a household that has children under the age of 18 within it. So how can these elderly communities discriminate against families with children? Well, the answer is that in the Fair Housing Act, there is an exception for what's called housing for older persons. And the exception can be qualified in either of 2 ways. There are 2 different criteria that will satisfy the law. One of them is that the development has all residents being 62 years or older. That's the more strict of the 2 tests. The more lenient test is like this. 80% of the units have to have at least one person who is 55 years of age or over. Now, obviously, it's much easier to satisfy the second test. However, if a development decides to use the second test, they have to provide verification of the ages of the residents with reliable surveys and affidavits, and they have to do that at the time a unit is rented or sold, and then every 2 years thereafter they have to re-verify the ages of the people living in the development. So that means it's a good deal more complex in terms of administration, but it does allow much greater flexibility in terms of who can move in. No permanent resident under either test may be under the age of 19. So in effect, if you're building or developing housing for older persons, you are required to discriminate against households with children in them in order to satisfy the housing for older persons exception to the Fair Housing Act. Well, that completes what we need to cover about the interpretation and application of covenants. Now we're going to turn to a different topic, how covenants can be terminated. We're going to list a variety of ways, about half a dozen ways or more, that covenants can come to an end and no longer be applicable. And as we look at each method of terminating a covenant, we're going to ask the question, does that method apply both to a covenant that burdens only an individual lot, a sort of freestanding lot, and also to a covenant in a common plan subdivision? And what we're going to discover is that most of the methods apply in either of those contexts. The first method of terminating a covenant that we want to look at is called a waiver. Let's imagine that A and B own lots side by side, and B enters into a covenant with A, promising not to raise pigs on B's land. Later, A sells the benefited land to A2, and B says to A2, I'm thinking about raising some pigs on my property. And A2 orally states to B, well, I really don't mind if you put some pigs on your land. Now, is that a waiver of the right to enforce the covenant? It certainly seems to be a valid waiver. It was only an oral statement, though, and so we might ask the question, is compliance with the statute of frauds necessary? Do we need a writing, in other words? But the answer is very likely no. An oral statement will work just fine. Now, that same process could happen in a subdivision, but it isn't very likely because it would involve a statement by all of the burdened land's neighbors stating to the owner of the burdened land that they don't mind that owner violating the covenant. That just isn't very likely to occur, but it's possible. A second method of terminating a covenant is called abandonment. Again, let's suppose that A and B own lots side by side, and B promises A that B won't raise any pigs on the property. Now let's suppose that B does, in fact, begin raising pigs on B's land, thereby violating the covenant. But A doesn't do anything about it. A doesn't say anything, doesn't take any legal action, and many years go by with B violating the covenant. Is the covenant abandoned and thus terminated? And the courts generally will say, yes, if a long period has elapsed with no action to enforce the covenant, it has been abandoned and now it can't be enforced anymore. Suppose A waits longer than the statute of limitations period. Instead of abandonment, the courts might say that the covenant has been terminated by prescription, by the running of the statute of limitations. But it's a similar idea. Now, could that happen in a common plan subdivision? Well, the answer is yes, it could. You could have an abandonment of the covenants, but it would require widespread or general abandonment throughout the subdivision. Not necessarily that every lot would have a violation on it, but that a large number of lots would have violations, and nobody in the subdivision had taken any action to enforce the covenants against them for a long period of time. Another theory that's often used to terminate covenants, and this one is very widely litigated, is called the theory of changed conditions. The concept here is that there have been changes in the area, changes so extensive that the purpose of the covenant simply can't be achieved any longer. And if that happens, the court will terminate it. In effect, will declare that it can't be enforced anymore because it doesn't make any sense to enforce it if its purpose can't be achieved. The basic character of the area or neighborhood where the land is located must have changed in order for this theory to work. Usually the changes are violations of the covenants in the same subdivision. So even though the particular lot in question doesn't have any violation on it, if there are widespread violations on other lots in the same area, the court may find that the character of the area has changed and therefore its purpose can't be achieved anymore. The changes have to be very close to the lot in question. Usually, as I say, they're in the same subdivision, although this theory can apply to an individual lot subject to a covenant if the area around it has changed in its character. Zoning changes by themselves are generally not enough to cause a termination. Even though the zoning now allows for different uses that would violate the covenant, that by itself will not constitute changed conditions. However, you can imagine a case in which the zoning and the covenants have changed so that there is now no opportunity to develop the land at all. In other words, the only uses that the zoning ordinance allows are uses that the covenants prohibit, so that an owner of the land simply could not comply with both and couldn't develop the land in any way at all. In that situation, the courts are very likely to find that the conditions have changed, that the covenants now can't be enforced anymore, and that the owner can develop the land in compliance with the zoning ordinance. A fourth theory that's sometimes used to terminate a covenant is the theory of estoppel. Let's imagine we have our pig covenant, where B promises A that B won't raise any pigs on B's land. Now, B begins building pig pens on the property and erects a sign that says, "Coming soon, ham for sale." Well, this is pretty good evidence that B is about to violate the covenant. A sees these facts but doesn't take any action at all. B spends many thousands of dollars preparing the land for the raising of pigs. Now is A stopped from enforcing the covenant? Well, it's conceivable that a court will find an estoppel on these facts, But you'll notice this is a little different than the waiver case we talked about earlier, because in this case, A hasn't affirmatively said anything. A hasn't made any affirmative representations. So all A has done really in this case is to be silent in the face of evidence that B is about to violate the covenants, and the courts are very, very reluctant to find estoppel from silence. It's conceivable, but it's really a long shot. Now let's review what we've learned so far. We've talked about waiver, abandonment, estoppel, and changed conditions. The same or very similar facts might give rise to any one of these four theories. All four of the theories could apply either to an individual freestanding lot or to a covenant that governs a common plan subdivision. But most of the changed conditions cases involve a group of lots, usually a subdivision, and what usually happens is that the subdivision, according to the covenants, is designated for single-family residential use only, and what happens is that the lots begin to be used for commercial purposes instead, and if quite a large number of them are now used for commercial purposes, even though that's obviously a violation of the covenants, the court may very well find that changed conditions have occurred. In a subdivision, waiver and estoppel only can apply if the violation is on the defendant's lot. In other words, the lot in question is where the violation is occurring. On the other hand, both abandonment and changed conditions in a subdivision may arise if the violations are widespread on other lots, even though the particular lot that the defendant owns doesn't have a violation on it. So there's a subtle but important difference between waiver and estoppel on the one hand and abandonment and changed conditions on the other. Covenants in subdivisions often contain multiple provisions, multiple restrictions of various types on what can be done on the lots. And it's important to realize that under the theories we've talked about so far for terminating covenants, terminating one provision in a set of covenants does not necessarily terminate all of the covenants. Some of the other provisions may very well survive. The covenants, in other words, are treated individually within the set of CC&Rs. For example, let's suppose we have a set of CC&Rs in a subdivision that provides first that only one single-family house may be built on each lot, and second, that no sheds or outbuildings may be erected on any lot. Now let's imagine that many of the owners in the subdivision build outbuildings. They do it illegally, they're violating the covenants, but people are putting up sheds and detached garages and pool houses, and all of these have been constructed without any attempt by their neighbors to enforce the covenant. Well, the covenant dealing with the outbuildings may very well be held abandoned or waived, or it's possible that even the court will say that there's been a change of conditions. But that only applies to the covenant dealing with the outbuildings. The single-family house covenant is still perfectly enforceable. Now here are a couple of additional ways that a covenant might terminate. The first one is release. Let's go back to our pig covenant where B promises A that B won't raise any pigs on B's land. Now suppose A later comes to B and gives B a written document, a piece of paper signed by A that says, I, A, will no longer claim any right to enforce the covenant. Well, that's simply a release of A's covenant rights, and obviously it will terminate the covenant. Here, there's no question about the statute of frauds. It's been done with a written document. In a common plan subdivision, it's much harder to pull this off, although it's possible, because for B to be able to raise pigs in a common plan subdivision, B would have to go to all of the other owners, and all of them would have to release their rights by written documents. If there's even one holdout, the release won't be complete, and B will still be subject to the possibility of a lawsuit if B puts pigs on B's land. Now, suppose instead of a release, suppose the same person buys both A's land and B's land. Is the covenant terminated? Well, yes, it is, and the theory, of course, is merger. In other words, you can't have covenant rights against your own land. You can only have covenant rights, the right to enforce the covenant, against someone who owns some other land. So if the same person owns both the benefited and the burdened land, the covenant is automatically terminated. By the way, this could happen in a subdivision as well, but again, it isn't very likely because what it would mean is that the same individual would need to buy all of the lots in the common plan subdivision, and that just isn't very likely to happen, but it is possible. Enforcement of a covenant might also be prevented by the doctrine of unclean hands. To illustrate that, let's go back to our pig covenant, but this time let's assume that it's a mutual covenant. Both A and B promise one another that they won't raise any pigs on their respective properties. So each of them is bound to the other by the same promise. Now let's suppose that later both A and B put pigs on their properties, so both of them are in violation of their covenants. Now A sues B to enjoin P from raising pigs on B's land. B's response is likely to be, well, you're just as bad as I am. You're trying to enforce a covenant against B, but you're essentially violating the same covenant yourself. So you have unclean hands. And if that's the case, the court very likely will refuse to allow A to enforce the covenant against B because A has unclean hands. Could that happen in a subdivision? Well, yes, it could. One neighbor might sue another in a subdivision, a common plan subdivision, to stop the violation of a covenant the plaintiff himself or herself is also violating. So if the court finds that the neighbor's got unclean hands, the court will probably refuse to enforce the covenant. Now here's a little list of 3 other ways that a covenant can terminate. These aren't as likely to be litigated as the ones we've already talked about, but they're possible. The first one is eminent domain. Suppose a court allows the government to take over and take title to a piece of land that is subject to a covenant. That means that the party who would have been able to enforce the covenant on that property can no longer do so. The benefited party basically has had the benefit taken away by virtue of the eminent domain action. They can't enforce it against the government. So is the person whose land is benefited by the covenant now entitled to compensation? Well, in concept, the answer surely ought to be yes. The right to enforce a covenant in our legal system is thought of as a real property right, and if the government takes away your real property rights, the government has to compensate you. That's familiar eminent domain law. However, the courts have struggled a bit with this issue, and sometimes they have refused to do this. They've refused to give compensation to the benefited party on the ground that the benefited party might be in some sense running a scam against the government. I think that's really quite unlikely, particularly if the covenant was in place long before any eminent domain action was contemplated by the government. So in concept, the person who had the benefited land ought to get compensation. A second possibility is a tax sale. In theory, a tax sale sells the property free and clear of all encumbrances, and that means whoever buys at a tax sale would be free of any previous covenants that have been imposed on the land. However, that seems to be quite an unfair result to the neighbors, and so a number of states have statutes that preserve the covenants when the burdened land is sold at a tax sale. You just have to check the statutes of the individual state to see whether that will work or not. Yet a third possibility is the covenant might simply expire by its own terms. Many times, covenants will have a specific limited life. They might have a life of, for example, 20 years. Now, often there will be a provision for extending that life by the neighbors in a subdivision, some extraordinary majority of them recording a declaration that they simply want the covenant to continue. But if that hasn't happened, at the end of the life specified in the covenants will terminate of their own accord. To summarize, we've learned about a number of ways that covenants can be terminated. We'll list them here just by way of review. There's waiver, abandonment, changed conditions, estoppel, release, merger, unclean hands, eminent domain, and a tax sale. Our next videos are going to be about easements, and when we cover termination of easements, we'll see that most of the methods of terminating covenants apply to easements as well. So that's a useful list to remember for both easements and covenants. To conclude this video, we need to say a few words about amending the covenants. After all, no one's a perfect prophet, and often conditions change sufficiently that the original covenants don't work very well, so amendments may be necessary. Well, what percentage vote in a common plan subdivision is required to amend the covenants? Well-drafted covenants will always provide an amendment procedure, and usually they'll provide for a vote that's a supermajority but not unanimous. For example, they may require a vote of 60%, 2/3, or even 75%. If there isn't any method of amendment provided in the original covenants, however, then less than a unanimous vote simply won't work. Everyone will have to vote for an amendment to the covenants. That's why an amendment procedure is very desirable. If the amendments are made by less than a unanimous vote, there are some things they simply can't do. The courts won't let them do the following things. First, they can't accomplish a complete destruction, or some courts would say a radical alteration of the covenants, unless there is a unanimous vote of approval. Second, they can't be contrary to public policy or illegal. And finally, according to many courts, they can't be non-uniform in a common plan subdivision. There's a sort of an implicit requirement that common plan subdivisions have uniform covenants on all of the lots. So those are the limitations that the courts impose if less than a unanimous vote to amend the covenants is held. That completes our video about construing and terminating covenants. In our next video, we'll begin a sequence on easements with a video about the basic concepts of easements. I hope you'll watch. If you have questions or comments, email ProfDale01@gmail.com. Thanks for watching.